This is the second of 6 quick educational videos in a series that we are doing on estate planning. So, are you confused about the differences between a will and a trust? If so, you're not alone. Today's video is a quick rundown on the differences between the two. First, what can a revocable living trust do that a will cannot do? The first thing is avoiding guardianship proceedings. A revocable living trust allows you to pick someone that you trust to manage your assets should you become incapacitated and unable to manage your own affairs. Wills only become effective when you die, so they are useless in avoiding guardianship proceedings during your lifetime. Second, a trust allows you to bypass probate. Property in a revocable living trust does not pass through the probate process. Only wills go through probate. Third, a trust allows you to maintain privacy after death, and it protects your family's privacy as well. Wills are public documents, trusts are not. So, anyone with an internet connection can discover the details of your estate if you have a will. Fourth, a trust can help protect you from court challenges. Attacking a trust is generally much harder than attacking a will because a probate provides a forum for someone to appear at court and attack the will. Now let's talk about what a will can do that a trust cannot do. First, a will can name guardians for your children. Only a will can name guardians to care for minor children. Second, a will can specify an executor or a personal representative. Wills allow you to name a personal representative to wrap up your estate after you die. This typically involves working with a probate court, protecting assets, paying your debts, and distributing what remains to your heirs. But if there are no assets in your probate estate because you have fully funded your revocable trust, then this feature is not necessarily a useful feature. Lastly, what can both wills and trusts do? Both wills and revocable trusts can be revised whenever your intentions or your circumstances change. Both wills and trusts allow you to name beneficiaries for your assets. Wills simply describe and state who gets what. While trusts are similar, you must go one step further and transfer property into the trust. This is commonly referred to as funding or trust funding. Only assets in the name of your trust will be controlled by your trust. So, to recap, I hope you can see that some of the differences between wills and trusts are subtle, while others aren't necessarily so. But together, we can discuss your goals as well as your family situation and design an estate plan tailored to your specific needs and your family's needs. I hope you're finding these videos helpful. Watch out for our next video that will describe the Oklahoma probate process and why you might want to avoid probate. And if you're ready now for a free estate planning consultation, just call us or use the link below to schedule yourself at a time that's convenient. Thanks again, and we'll see you next time.